So there has been a recent push to record inside of public buildings in the First Amendment auditing community. I suspect it's due to a lack of pushback from recording in public, like from sidewalks. So they're trying to escalate it for clicks, for views, etc. Now, I don't necessarily dislike that, but it is not. There is no right to record inside of public buildings currently, unless a state law grants it. There is no right to do so. There is no right that prevents you from being trespassed for recording. And I'm not saying that there should or shouldn't be. I'm just saying that that is the state of the law. Now, I'm seeing a lot of stupid people make stupid claims about where you have the right to record. Now, the right to record is based on your First Amendment freedom of speech. Uses the same tests as the freedom of speech. So you see things like these clowns think they can order you off publicly accessible areas of publicly owned property. That's not the test. Public property does not give you the right to record. Publicly accessible property does not give you the right to record. Publicly owned property that's publicly accessible, even if you combine them, there's no right to record just from that. Where do you get the right to record from? Well, again, it comes from your freedom of speech. So you got to start back with Hague v. CIO. This is a Supreme Court case from 1939, U.S. Supreme Court. Hague versus the Committee for Industrial Organization. The relevant portion of this case that you will see throughout First Amendment cases is this. Wherever the title of streets and parks may rest, they have immemorially been held in trust for use of the public and, time out of mind, have been held for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Such use of the streets and public places has, from ancient times, been a part of the privileges, immunities, rights, and liberties of citizens. The privilege of a citizen of the United States to use the streets and parks for communication of views on national questions may be regulated in the interests of all. It is not absolute, but relative, and must be exercised in subordination to the general comfort and convenience, and in consonance with peace and good order, but it must not, in the guise of regulation, be abridged or denied. This is the beginning, this is the start, this is the codification of the traditional public forum test. Traditional. They've immemorially been held in trust. Traditional. Since time out of mind. Traditional. Ancient times, from ancient times, it's a traditional public forum. Every time you've seen a street, every time you've seen a sidewalk, every time you've seen a park, there's been communication of ideas. So from that, we move to Adderley. Adderley v. Florida. Justia spells it wrong. It's Adderley. There's an E in there. I don't know why they don't have an E in there. It's Adderley v. Florida. But whatever. U.S. Supreme Court case, 1966. Some students went into the curtilage of a jailhouse. They were on the driveway that's not normally used by the public. They were also on the lawn. And the Supreme Court held that the sheriff, as a jail custodian, had the power, as the state courts have here held, to direct this large crowd of people to get off the grounds. Not off the driveway, but off the grounds. There's not a shred of evidence in this record the power was exercised, or this exercise was sanctioned by lower courts because the sheriff objected to what was being sung or said by the demonstrators, or because he disagreed with the objectives of the protest. it was content neutral. He didn't care what they were saying, singing. He didn't care why they were there. He just didn't want them there. Content neutral. The record reveals that he objected only to their presence on the part of the jail grounds reserved for jail uses. There is no evidence at all that on any other occasion had similarly large groups of the public been permitted to gather on this portion of the jail grounds for any purpose. So this is going back to the traditional public forum. There's no history of people using this part of the jail grounds for free speech purposes. Nothing in the Constitution of the United States prevents Florida from even-handed enforcement of its general trespass statute against those refusing to obey the sheriff's orders to remove themselves from what amounted to be the curtilage of the jailhouse. Now, curtilage is it's a term that you'll really only hear in law. Like on a house. Like, let's say you have a farmhouse. The curtilage of the farmhouse would be like the front lawn, the backyard, any side yards that are kind of like right around the house. Any fields surrounding the house, like crop fields or whatever, would not be considered part of the curtilage. It's the living area, basically, of a house. So in this instance, the curtilage of the jailhouse would be the driveway. It would be the front lawn. It would be any side lawns, any rear lawns of the jail. So it's not just the driveway. It's everything kind of surrounding the jailhouse. So if the jail had like a parcel of property next to it, a field next to it that they had purchased for future expansion but hadn't done anything with yet, that would not be curtilage. Or you can make an argument that it's not curtilage, or that it is, but it probably would not be considered curtilage. Back to the text. The state, no less than a private owner of property, has the power to preserve property under its control to the use, or for the use to which it is lawfully dedicated. For this reason, there is no merit to the petitioner's argument that they had a constitutional right to stay on the property over the jail custodian's objections, because this area chosen for peaceful civil rights demonstration was not only reasonable but particularly appropriate. So that argument that the area was reasonable but particularly appropriate, that doesn't mean anything. Well, it's not good law. Such an argument has as major unarticulated premise the assumption that people who want to propagandize protest or views have a constitutional right to do so whenever and however and wherever they please. That concept of constitutional law was vigorously and forthrightly rejected in two of the cases the petitioners rely on. We reject it again. The United States Constitution does not forbid a state to control the use of its own property for its own lawful non-discriminatory purpose. So I think that pretty much dismantles the idea that publicly accessible areas of publicly owned property are ripe for any First Amendment activities, that you have a unassailable right to be there. But in case you're not satisfied, let's go to Greer v. Spock. Greer v. Spock is again a U.S. Supreme Court case. This is from 1976, in which Greer was a candidate for president, some People's Party, and he wanted to leaflet and hold political activities on Fort Dix. And the Supreme Court roundly rejected it. However, for purposes of our discussion, please note that civilian vehicular traffic is permitted on paved roads within the reservation, and civilian pedestrian traffic is permitted on both roads and footpaths. Military police regularly patrol the roads of the reservation. They occasionally stop civilians and ask them for the reason of their presence. Signs posted on roads leading into the reservation say all vehicles subject to search while on the Fort Dix military reservation, and soliciting prohibited unless approved by commanding general. The main entrances to Fort Dix are not normally guarded, and a sign at one of the entrances says visitors welcome. Civilians are freely permitted to visit unrestricted areas of the reservation. You would have a hard time convincing me that a military base is not publicly owned property. And judging by what the court is saying here as the underlying facts of the case, you would have a hard time convincing me that it is not publicly accessible. So we have publicly owned property that is publicly accessible, and yet the state can forbid you from engaging in First Amendment activities there. Now, if that doesn't convince you, we have one more case. This is the International Society for Krishna Consciousness versus Lee. This is also a United States Supreme Court case from 1992. The Krishnas were wanting to solicit and hand out literature in the concourse of an airport, publicly owned airport. You have to remember this is before 9/11. This is back when you could simply walk up to the gate at an airport. You know, you could go there without a ticket and watch planes land. It didn't have all the security keeping the public out of the concourses and stuff like that back in this time. So let's see what the court held as the facts in this case, where again they said that it's not a traditional public forum. They said the airports are funded by user fees and operated to make a regulated profit. Most spaces at the airports is leased to commercial airlines, which bear primary responsibility for the leasehold. The Port Authority, that is a public entity, retains control over unleased portions, including LaGuardia's Central Terminal Building, portions of Kennedy's International Arrivals Building, and Newark's North Terminal Building. We refer to these areas collectively as the terminals. The terminals are generally accessible to the general public. Well, that's interesting. And contain various commercial establishments such as restaurants, snack stands, bars, newsstands, and stores of various types. Virtually all who visit the terminals do so for purposes related to air travel. Those visitors principally include passengers, those meeting or seeing off passengers, flight crews, and terminal employees. IBID. So you have, and again, this is a public property accessible by the public, where the court has held that the state can limit your First Amendment expression. So, to recap, public property does not give you the right to film in and of itself. Publicly accessible does not give you the right to film in and of itself. Public property that's publicly accessible does not in and of itself give you the right to film. If it is a traditional public forum, you are on very, very, very solid footing for filming. But it has to be a traditional public forum, or a limited or designated forum that's been opened up. Like if the police are holding a news conference in their police station, then you have a darn good argument to make that you should be allowed to go in there and film it. It would have to be litigated. I'm not sure exactly how you'd fall on that, but you'd have a very good case for it. But if they're not opening up their police station for a news event, then you can't just go in there and say, "Oh, I'm gathering news," or "Oh, I'm here to film your plaques," and expect that they cannot trespass you. Now, I could be wrong. I don't claim to know how a court would come down on any particular case, and I'm not saying that it's right that you can't film inside a police station. I'm also not saying it's wrong. I'm just saying that the state of the law currently makes it very likely that you can't, or that the police can trespass you from filming inside of a police station, even in publicly accessible areas. So there's another gentleman who went in to pay a fee or a fine, and was pissed off taxpayer, I believe his name was, and they told him that he couldn't film while he did it. And then they ended up trespassing him, and then they arrested him for criminal trespass because he didn't leave when they trespassed him. One of the arguments that they're making is that this person is there to pay a fine, therefore he should be allowed to film. Well, if you're there to pay a fine, that's fine. You can pay the fine, but that doesn't mean that they have to allow you to do other First Amendment activities. Imagine going in to pay a fine and using a bullhorn to yell at the people behind the counter. That's a First Amendment activity. You're there to pay a fine, but that doesn't mean that they can't stop you from doing that. Anyway, I hope that was informative and helpful, and I hope you appreciate the super high quality production, and have a great day.